Welcome to my channel. Please like, comment, and subscribe. Maritime employment really is not for anyone who needs to work in a relaxing and stress-free environment. This is especially true for maritime personnel who spend their days on oil rigs. It is not easy working on this platform. Not only can it be physically strenuous, it routinely exposes employees to a wide range of dangers from inclement weather to toxic chemicals. Worse still, oil platforms are typically situated in remote locations, which can complicate rescue operations. Due to these workplace conditions, serious injuries, even fatalities, are all too common occurrences. The good news is that oil rig workers can qualify for financial compensation if they become injured on the job. For oil rig employees, it is important to know about the Outer Continental Safelands Act, which protects and extends their right to obtain just compensation for their on-the-job injuries. The OCSLA governs the U.S. controlled offshore territory known as the Outer Continental Shelf. A continental shelf is essentially the submerged land, the seabed, and subsoil that extends beyond the mainland. In the U.S., any particular part of the continental shelf is, for the most part, considered to be under the jurisdiction of the adjoining state so long as the area in question is no farther than 3 miles from the state's coastline. However, what about the submerged land outside the 3-mile boundary? This is known as the Outer Continental Shelf, or OCS. It is divided into 4 distinct regions under U.S. jurisdiction: Gulf of Mexico OCS region, Atlantic OCS region, Pacific OCS region, and Alaska OCS region. These areas are under federal control and outside the jurisdiction of neighboring U.S. states. This fact has far-reaching implications for maritime personal injury law and the options available to personnel who seek to collect compensation for the harm they have suffered on the job. The Jones Act, otherwise known as the Merchant Marine Act of 1920, is probably the most widely recognized piece of legislation that governs personal injury claims in the maritime sector. It grants a seaman the right to sue an employer whose negligence resulted in serious injury to the worker. As Jones Act compensation can be substantial, especially when compared with state workers' compensation, this is an attractive avenue for many. However, it must be understood that this right to compensation is given only to those who qualified as seamen under the definition of the Jones Act, and many maritime workers fail to meet the requirement. Under the Jones Act, a seaman must meet several criteria. The one that causes problems for many maritime employees is the requirement that the individual is employed on a vessel in navigation. Oil rigs, which are often fixed in position, tend not to fulfill this requirement. There are situations where oil rig workers can meet this requirement, although these are not common, and you need to consult with a maritime accident attorney to be able to determine whether your particular case is applicable. In summary, oil rigs workers usually do not qualify for Jones Act protection. So, where does that leave them? This is where the OCSLA comes into play. As the United States became increasingly industrialized over the course of the 20th century, the importance of oil and other natural resources grew accordingly. The Outer Continental Shelf assumed a hugely important role in this national trend, as the area was known to be rich with such resources. In 1953, the Outer Continental Safelands Act, or OCSLA, was passed to define the jurisdiction of the federal government over these regions and to grant the Secretary of the Interior the power to list them to organizations for the purpose of finding and developing natural resources. Today, the Bureau of Ocean Energy Management, an agency of the U.S. Department of the Interior, oversees the development of wells and pipelines across the OCS. The OCSLA also has significant implications for oil rig workers. Under the OCSLA, they can generally qualify for personal injury compensation that the Jones Act denies them. Employees who are involved in the exploration, development, removal, or transportation of natural resources on navigable waters in the outer continental shelf are eligible for personal injury compensation under the provision of the OCSLA. This includes not only oil rig workers but longshoremen, shipbuilders, and other personnel engaged in related activities. Qualified personnel must have been engaged in duties on a temporary or permanent installation on the OCS at the time of the incident in question. The OCSLA does not cover individuals who are crew members of a vessel. That's basically what the Jones Act is for. It also does not cover employees of the United States government or the government of any foreign power. Oil rig workers and other maritime personnel covered by the OCSLA can collect personal injury compensation through the Longshore and Harbor Workers' Compensation Act. In fact, the OCSLA can be viewed as essentially an extension of the Longshore and Harbor Workers' Compensation Act. The Longshore and Harbor Workers' Compensation Act is fundamentally a workers' compensation program that was originally enacted back in 1927 and later was subjected to various modifications to broaden its scope. Among these modifications was an amendment of the Act to include coverage for maritime employees in the outer continental shelf. If he or she qualifies for Longshore and Harbor Workers' Compensation Act compensation, an injured oil rig worker will be classified in one of four main disability categories. This determination is based on whether the injury is temporary or permanent in nature, and whether it is total or partial in extent. The four categories are as follows. First, temporary partial disability or TPD. The employees are capable of performing at least some duties. During the recovery period, they will receive compensation set at 2/3 of their estimated loss of earning capacity. Second, temporary total disability or TTD. Employees will receive compensation set at 2/3 of their average weekly wage, based on the last 52 weeks of wages. And then third, permanent total disability or PTD. Employees will receive compensation set at 2/3 of their average weekly wage. PTD compensation lasts for the duration of the worker's disability. And then fourth, permanent partial disability or PPD. Employees will receive compensation set at 2/3 of their average weekly wage plus compensation based on the part of the body that is impaired. Thank you very much for watching. Don't forget to always give a like, comment, share, and subscribe.